everybody, this is Arkady Frekhtman, a New York City personal injury trial attorney, and today we are talking about open reduction internal fixation, or ORIF, and we're going to look at verdicts in New York, verdicts and settlements that are recent in New York. So let's get started. What is open reduction internal fixation? Well, it really is the surgeon using an incision to access the bone and realign it him or herself because the bone needs to heal properly. And so the fracture is so bad that it's never going to heal on its own. And so the surgeon has to get in there and realign it. And then after the fracture is reduced or realigned, there's internal fixation, which means that they're going to be putting in hardware such as pins, plates, rods, screws, or a combination of all of these to hold the fracture in place. So the surgeon is going to do that, and he's going to hold all those bone fragments together with the rods, pins, plates, and usually it's under general anesthesia. So let's look at some recent verdicts. Here's a verdict from September 21st of 2022, and it actually happened out in Albany. What happened here was a 12-year-old plaintiff was a pedestrian, and she was struck by a vehicle driven by the defendant. And allegedly the plaintiff was sitting at a curb at the time. And she suffered a displaced fracture that's a transverse fracture of the shaft of the left femur, requiring open reduction internal fixation, which is the topic of today's video. And she needed intramedullary nailing, which is a type of fixation. So that's a really serious nailing. And she claimed that the defendant was negligent and that they failed to see her. And the parties were on trial, and they ended up settling the case. And the settlement in this case, which happened upstate in Albany, was $200,000. So it's not like a huge amount, but it's not a terrible amount either. It's a pretty fair amount. And I actually recognize the attorney. I think actually this attorney used to work with me a few years ago here in this firm, but now he's at another firm. He's a good attorney. He's a very nice guy and very personable. So I'm sure he was doing a good job as a trial attorney in that case. Okay, let's go to the next case. The next case is a case from Suffolk County, and let's see what this one is about. This one looks like also a lady, and she claimed to suffer a left elbow fracture requiring open reduction internal fixation and repair of the collateral ligament, the lateral collateral ligament, and resulting in a decreased range of motion and deformity of the elbow when she tripped and fell in the driveway of a home. And she argued that the defendant was negligent in failing to install a railing or a fence on the edge of the steep driveway, causing or allowing a drop-off to exist and failing to warn of this dangerous condition. And the defendant denied liability, arguing plaintiff tripped over a decorative railroad tie while she was looking up at the sky. So the result of this case was actually a defense verdict. So the plaintiff lost this case. So I guess the defendants agreed. And actually I recognize the lawyer, I believe this is the same lawyer, the lawyer for the defendant on this one that I know him. He's also a really nice guy. I see him sometimes when I pick juries in Brooklyn and other places, and I've known him for many years. So yeah, this case was unfortunately a defense verdict. Okay, let's go to the next one. The next one is in Ulster County, which is upstate New York. And this one involved also a female who sustained injuries. She sustained a 3-part proximal left humerus fracture, that's the shoulder, the humerus bone, which required open reduction internal fixation surgery, including implanting a locking plate with 7 locking screws, 2 cortical screws, and 1 locking screw in the shaft, as well as bone grafting. And she developed a post-surgical reflex sympathetic dystrophy, RSD. That's a very serious injury. She tripped and fell over a damaged chicken wire fencing surrounding an apartment complex owned by the defendant. The plaintiff argued that the defendant failed to routinely inspect and properly maintain its property and created a trap, a hazard, or a nuisance with this downed chicken wire, creating improper conditions for pedestrians. The defendant filed a motion for summary judgment, arguing it did not own the property on which the plaintiff fell, but rather the town of Ulster was the real owner. And a jury actually found plaintiff 30% at fault for her own damages. And the verdict for all of these damages was $750,000. So the total compensatory award for the pain and the suffering, past and future, was $750,000. But because the plaintiff was 30% at fault, the plaintiff cannot recover the money, for their own percentage of fault. So then the verdict received by the plaintiff was only 70% of the verdict, or $525,000, which with the addition of costs totaled $539,144.40. So it's still not a bad result. It would have been better if she could have gotten the whole $750,000, but still not a bad result. Okay, let's see. Here's the next one, is in Sullivan County. Now, Sullivan County is the Catskills. That's like Monticello, that area. I've had some trials up there. Don't really do too many cases up there, but let's see what happened here. So in this case, an adult man argued that he sustained a left mid-shaft clavicle fracture, which required open reduction internal fixation, and he was at a property owned by the defendants. It was a congregational mazad, some kind of religious organization, and they were performing work. While he was performing work, a standing safe fell on top of him, and he argued that the defendants failed to own, operate, and maintain these premises in a reasonably safe condition and were the cause of his permanent injury. The defendants denied liability, and they claimed the plaintiff was solely responsible for his injuries, and a jury returned a verdict in favor of the plaintiff. And what happened was they gave him compensatory pain and suffering of $500,000, compensatory past medicals of $25,241, and a total compensatory award of $525,241. So over $500,000 in, up in Sullivan County is a pretty good result. Sullivan County is a tough venue, pretty conservative venue, so it's a good result. But he had a serious injury. Okay, the next case is in Onondaga County, and that's in Syracuse. I just know that from the last video I did because there was a case up there as well. And so in this case, what happened was an adult man suffered serious injuries, including multiple fractures of his left lower leg, requiring open reduction internal fixation surgery with plates and screws and application of an ankle spanning external fixator. So that means that he had internal fixation in the fracture of his leg, right? You could have the plate with screws in the leg, but it was so bad that he also needed rods outside the leg, external fixators, resulting in surgical scarring, as well as an S1 vertebra fracture with a presacral hematoma and a pelvic ring injury, and he was struck by a pickup truck with an attached snowplow operated by the defendant. The plaintiff argued that the defendant was negligent in failing to obey the rules of the road, failing to make proper observations of a pedestrian traffic, and failing to maintain control of his vehicle, as well as driving recklessly. Now, the defendant denied liability and noted that the plaintiff was wearing dark clothes. It was an unlit section of highway at night when the incident occurred. And the jury ultimately returned a verdict in favor of the defendant. He got 0 for all of these injuries. I guess they agreed that he must have been at fault for being in the middle of the road. It was a tough case because I guess an unlit roadway, maybe the pedestrian was not supposed to be there wearing dark clothes. And also it happened up in Syracuse in Onondaga County. Maybe that's a very conservative jurisdiction. I'm not too familiar with way up there. Okay, and then the next case is in the Bronx. And what happened here was, let's see here. So it was a minor, and she suffered a left fifth distal phalanx pinky fracture, which required open reduction internal fixation after a door slammed on the finger while living at a shelter owned and operated by the city of New York and other agencies of the city. And the mother sued the city and argued that they failed to keep the shelter in a reasonably safe condition, free from traps and dangers. And and then they just argued that she suffered physical injury when they negligently maintained a defective door of this particular unit, and it slammed on her hand. And they ultimately reached a settlement during the trial, and the total settlement was $50,000. So it's not a terrible settlement. I mean, it's a finger, but it did need Orif, which is a serious injury. So I suppose, it's probably the liability wasn't that strong, because I'm thinking in the Bronx, if the liability was stronger, they would have probably taken a verdict and gotten much more than 50. Okay, let's do the next case. The next case is in Nassau County, and it is a case where a 13-year-old man or boy reportedly suffered a right comminuted tibia fracture, a right non-displaced fibula fracture, right leg nerve injury, compartment fasciotomy, and an application of an external fixator also. So this is a serious injury, an open reduction, internal fixation, and a motorcycle he was a passenger on was involved in an accident with another motorcycle. So the minor plaintiff's mother brought this action for personal injury, and the defendants both denied liability. And there was a total, let me see if it was a settlement or a verdict. It was actually a settlement during trial, and the settlement was also for $50,000. So probably, I'm thinking these motorcycles probably had limited policies, because if they had higher policies, these injuries are horrific. It's worth a lot more than 50. Probably, maybe they each had 25,000, or it could be that one of the motorcycles had 50, the other one had something else, but maybe, one of them was at fault and the other one wasn't. So that's why they only settled for 50. But those are really serious injuries, especially in a 13-year-old. Tibia fractures, non-displaced fibula, fasciotomy, that's a really serious injury, and with an external fixator, plus the ORIF, the open reduction internal fixation, and that's all to his tibia and fibula. So that's his right leg was completely almost destroyed, really injured. Hopefully he recovers. He's a young kid, so hopefully he recovers and gets better from that. That's a serious injury. Okay, the next one is also in Suffolk County, which is Long Island, more out east toward the Hamptons, that area. So let's see what happened here. It was a 26-year-old man, and he claimed to suffer fractures of the left forearm that required open reduction internal fixation, which resulted in permanent scarring when he was driving his motorcycle on a highway, and the defendant merged her vehicle into the plaintiff's lane of travel, causing him to swerve to avoid a collision, lose control, and fall. So yeah, he was on... Yeah, so that sounds like also a motorcycle case. But really, this one, if she's entering his lane, you have to, before you change lanes, you have to look in the lane, make sure no one's in there. You can't be changing lanes when a motorcycle or a car is there. So the plaintiff argued the defendant was negligent in changing lanes without looking, driving at an unlawful rate of speed, failing to keep a vehicle under reasonable and proper control. The defendant denied liability and argued that the plaintiff's negligence was a substantial factor in causing the accident. The parties agreed that the plaintiff's total damages were $175,000 and stipulated to a binding summary jury trial. Now, I did videos on summary jury trials. It's a one-day trial, so everything gets decided in one day. But see, what they did here was they stipulated to a binding summary jury trial only to determine the issue of fault, because they both agreed that the total damages are $175,000. And so the jury found that the defendant was 60% negligent and the plaintiff received $100,000 in damages pursuant to a high-low agreement of $100,000 high, $15,000 low. So I'm thinking probably it was a $100,000 policy. I'm not sure, but because they had the 100 as the high. Yeah, interesting. But I mean, those injuries are worth probably much more, but maybe because of limited policies, people are stipulating to less. Okay, let's see what we have here. Here we have a case that involves a doctor and hospital malpractice, also in Nassau County. And let's see what this case is about. It's a 58-year-old woman. She suffered increased pain and a prolonged recovery after undergoing open reduction internal fixation with intramedullary nailing to treat a slip and fall injury, a right femoral fracture, an operation performed by the defendant doctor, who's an orthopedic surgeon and an agent of the defendant hospital. Now, the plaintiff argued that the defendants were at fault for failing to follow their own policies and procedures as they relate to the operation itself, her discharge from the hospital, and follow-up care. The plaintiff also argued that the defendants failed to ensure medical staff were properly supervised and that proper post-ORIF physical therapy was prescribed and that proper post-surgery instructions were provided. The defendant denied allegations and contended the surgery was hindered by plaintiff's morbid obesity, that she had problems because she's just, obese. So what happened was the jury deliberated on this case, and they ended up returning a verdict for the defendant, meaning that they did not find that the doctor made a mistake, or if he did make a mistake, the mistake did not cause these injuries. So they did not find medical malpractice, and they voted for the defendant. Let's see what other cases we have here. Here's a case from Queens. This is a case where a 9-year-old girl claimed she suffered a fractured left femur that required open reduction internal fixation when she was a student attending a public school. And she was climbing down a jungle gym on a playground, and she fell. She argued that the defendants knew of a dangerous condition on the playground and were negligent in allowing the unsafe condition to exist and remain, failing to repair the unsafe condition, failing to protect the plaintiff from injury, and failing to properly supervise her. And the defendants just denied liability. It doesn't say what the unsafe condition was, but maybe something was broken on the jungle gym. She had a femur fracture, and the case ended up settling. It settled for $75,000. I had a similar case where a boy was jumping up and trying to grab onto like one of these zip lines that you're supposed to grab the zip line and go zipping, you know, but what happened was they had removed the actual handle, and so it was just a bar, and as he jumped up, his hand slipped from the bar and he fell backward and he broke both his hands. I don't think he had surgery, but he broke both his hands, and it was a pretty bad break, and we ended up taking that case to trial in jury selection, and we ended up settling it, I believe, for $300, I forget if it was $325 or $350, but we settled the case. That was in Brooklyn. So very similar, but this one for some reason settled only for $75,000. I'm not sure why. With open reduction internal fixation, it sounds like a serious case. Okay, let's see what other cases we have. Here's a case from the Bronx. This is a case from the Bronx where an adult female suffered a fracture to the calcaneus of her left heel, which required open reduction internal fixation surgery and resulted in permanent impairment, as well as a distal fibular fracture with permanent limited motion of the left ankle when she fell down a stairway while lawfully on property owned by the defendant owner and leased by the defendant store. It was like a clothing store. The plaintiff contended the defendants failed in their duty to maintain the premises in a reasonably safe condition and had actual notice of a defective condition on the property and failed to timely repair or warn of same. The defendants denied liability and claimed the property was properly managed and maintained. And the jury ultimately returned a verdict for the defendant. That's interesting, because yeah, in the Bronx, usually you get plaintiff's verdicts, but I guess maybe the liability wasn't too strong. I actually see who the lawyer was for the plaintiffs. Actually a very good lawyer. I know them. They're excellent lawyers. And the defendants had one of these big firms, like a big white shoe type firm. So for whatever reason, maybe the jury believed the defendant, and unfortunately the plaintiff got nothing in this one, despite serious injuries. Okay, and here's a case from Suffolk County. This was a settlement for only $20,000. It was bimalleolar ankle fracture in a 14-year-old with Orif. They were riding a bike and struck by a car. I did a video on bimalleolar and trimalleolar fractures as well, where I talked about the most recent verdicts. Here's one in Queens. This one was, let's see what this one is about. An 11-year-old. For some reason, there's a lot of these cases with kids. An 11-year-old claimed he suffered a displaced left extraphyseal distal radius fracture and ulnar styloid fracture and was required to undergo open reduction internal fixation procedure. He was crossing an intersection and was struck by a vehicle owned and operated by the defendant. The plaintiff contended the defendant was negligent. The defendant denied liability. Here it was a settlement, and the settlement was $95,000. Okay. Probably, I think the policy was 100, because I recognize the defendants, and they usually have like 100,000. So maybe they just said, look, 95, close enough to 100. Let's just settle it, not risk it. Okay, here's a case from Westchester. This is a case from Westchester. Okay, this was an adult man. He suffered a left hip trochanteric fracture requiring an open reduction internal fixation when he slipped and fell in a dialysis treatment room at defendant dialysis clinic. And so he contended the floor in which he slipped was wet. And the defendants argued the floor was slip resistant and did not create a negligent condition. The defendant argued that the floor was not slippery, and therefore, regardless of whether it had actual or constructive notice of a wet floor, it did not represent or equate to a negligent condition that gave rise to any liability. And then the jury ultimately found for the defendant. The jurors determined there was not a wet floor where the incident occurred. And I recognize the defense firm. I have a lot of cases with them. It's a big firm. And I think I've heard of the plaintiff's lawyer as well. And they had an engineering expert. Oh, actually, the defendant had an engineering expert. But no, the plaintiff had an engineering expert as well. And I recognize the plaintiff's engineering expert. I haven't used him, but I've heard good things about this expert. So this is in Westchester. Yeah, Westchester could be a tough venue. I guess it's a tough case because, slip and fall in a dialysis center, maybe it's a negligible amount of water. I had a slip and fall case also in a dialysis center, but it was a little bit different. It was a failure to monitor the patient. Basically, the patient was saying, I can't get up. I am not able to stand. I have to be weighted in my wheelchair. And they kind of said, no, the doctor said you should stand up. They kind of pulled her up. And then she ultimately lost balance and fell and also suffered a bimalleolar, trimalleolar ankle fracture with open reduction internal fixation. And that case ended up settling for $300,000. So she was an older lady in her 70s and she was morbidly obese, which is why she couldn't stand, because she just doesn't have the ability to stand. Okay, let's do the next case. Here's a case from the Court of Claims. So that's against the state of New York. This was a defense judgment, 0. And it was a wrist fracture with Orif, with bone grafting surgery. It was a motorcycle case where he was driving a motorcycle and he encountered a 2-foot long, 1 foot wide, and 4 to 6 inch deep pothole on the roadway. And he went over the handlebars and landed on the ground. He argued that the defendant was negligent in failing to maintain the roadway and had a dangerous condition there. And the defendant just denied liability. And I guess the state of New York owned the roadway. So I guess it's a tough case, but for whatever reason, it was a defense verdict. Here's a case in Kings County, which is Brooklyn. And what happened here was a 12-year-old suffered a fractured left ankle that required open reduction internal fixation and resulted in permanent impairment. She was struck while crossing a street by the defendant. And she argued the defendant was negligent in the ownership and operation of his or her vehicle. Defendant argued that he had the right of way and that the minor just suddenly ran out in front of him. The case ended up settling, and the settlement was $98,500. And here is another case in Westchester. Okay, let's see what this one is about. This is a case in Westchester where a 36-year-old laborer argued that he suffered permanent paraplegia, a neurogenic bladder and bowel, an L1 fracture which required an open reduction internal fixation at T12L1 and posterior spinal fusion at T10 to L3, as well as a right pneumothorax, 5 fractured ribs, a scalp laceration, hematoma, depression, anxiety. So this is a really serious injury. He was working at a new home construction project with the defendant. Construction company was the general contractor, and he was on a ladder nailing plywood sheathing to the frame of a house when the ladder slipped and he fell 20 feet to the ground. He argued that the defendant violated the labor law by failing to furnish him with stable, secure ladder and failing to furnish him with proper safety devices. The defendant denied liability and contended the plaintiff never complained about the ladder prior to his fall, and it never heard anyone else complain about that ladder. The defendant claimed the plaintiff refused to use available safety devices, noticed the ladder was wobbling but continued to use the ladder, and did not request additional protections and leaned onto the side of the ladder without holding on to the ladder with either hand. The court granted summary judgment in favor of the plaintiff as to the liability of the 240 claim. Now, the reason for that is because when a laborer falls 20 feet, it's gravity related, and if it's gravity related, they don't look to whether or not the plaintiff was at fault. They just look to the fact that the construction worker should have been provided with proper safety devices. And if the ladder failed, then the proper safety devices were not provided, and it's as a matter of law. So then the verdict in this case turned out to be, so compensatory pain and suffering was $5 million. Compensatory future medicals were $11,300,000. Past wages were $58,500. and future wages were $580,000, and the total verdict was $16,939,255. That was a really serious case, really serious life-changing injury. Okay. Let's see what other cases we have. Maybe just do one or two more. I see a few defense verdicts here. This is just, by the way, this is just going from the most recent back and just searching for the term open reduction internal fixation. You could also sort them. You could sort them like, say, 5 million and up, and then you would only have the big verdicts, or you could sort them only the defense verdicts. But I figured I'll just do a mix of all the recent verdicts about this particular topic. Here's a settlement for $40,000. It was just a fracture of one finger with open reduction internal fixation. And it was also, so he went to his drama class after lunch. No school personnel were there. Him and his friends were playing, and somebody pushed a heavy door. The door did not properly close, and his fingers got caught. Yeah, it's a tough case, kids playing around, and, you know, I guess that's why it settled for only $40,000. Let's see what other cases we have. Here's one in New York County, that's Manhattan. And what happened here was that an adult male construction worker claimed he suffered a wrist fracture, which required open reduction internal fixation when he was working at a construction project at a building owned by the defendant, and where another defendant was the construction management company. He fell from a scaffold. He argued that the defendants were negligent in failing to abide by section 240, 241.6, and 200. The defendants denied liability and contended the plaintiff was negligent. They claimed that at the time of the incident, the plaintiff was on the scaffold while his co-worker was moving the scaffold, though he knew he should not remain on the scaffold while it was being moved. And they argued that prior to the accident, the plaintiff did not make any complaints about the scaffold, had no problems with the scaffold. They also claimed it did not direct, control, or supervise the plaintiff's work. And the court granted summary judgment in favor of the plaintiff on the 240 case. So again, because it's gravity related and he fell from a scaffold, they just give it to the plaintiff. They don't even let that go to the jury. And then the verdict was $280,000 for the injuries, a fractured wrist with open reduction internal fixation. So close to $300,000. Here's one in Queens County. It was a settlement for $125,000. It involved a 16-year-old with a displaced right clavicle fracture with open reduction internal fixation, comminuted right scapular fracture, multiple right-sided rib fractures, displaced right humerus fracture, and vertebra fractures at C7 through T3. She was a passenger in a car and lost control on the highway and struck a highway sign on the south shoulder. The plaintiff filed a lawsuit against the defendants. The defendants denied liability. The parties entered into a settlement agreement for the minor for $125,000. I don't know why the settlement was so low. Maybe the policy was limited and they didn't have access to more insurance, because those injuries are really, really severe. I'll do like one or two more. I'm trying to find something interesting that's a little bit different than the norm to give you guys a little bit of a taste of different cases. Here's one in Kings County in Brooklyn. It involved a 7-year-old suffered a fractured right femur requiring open reduction internal fixation and then an operation to remove the hardware. Because when you put in those plates and screws, oftentimes you have to also remove them once everything is fixated into place. And what happened, he was struck by a vehicle in front of an address and then just argued that the defendant was negligent. Pretty straightforward case. It settled for $225,000 during trial. And here's one in Richmond County, which is Staten Island. This one settled for $60,000. It involved an acute, mildly displaced supracondylar fracture of the right elbow, which required open reduction internal fixation surgery, a cast, physical therapy, left him with a slight deformity of the right elbow. He was attending an after-school program at the defendant's school, and he fell from the monkey bars. And the plaintiff argued the defendant was liable. The defendant denied. Doesn't really say what happened other than that. Suffolk County, a pedestrian crossing the roadway. This one went for $0. It was lost. And we have another Suffolk County settlement for $75,000, fracture of one finger. Seeing a few defense verdicts here. Defense verdicts meaning the plaintiff got nothing. That happens. Here is a Sullivan County case settlement of $25,000. That's really low. Let's see why it was so low. It was a dislocation of the left temporomandibular joint with a fracture involving the left condyle and ramus, and adjacent to the symphysis, and a laceration of the lower inner lip. Oh, I see. It was a fracture of the zygomatic arch that's underneath the eye, and a right body tubercle of the mandible adjacent to the symphysis. Oh, I see. And then it was a laceration of the lower inner lip, and she underwent an open reduction internal fixation, maxillomandibular fixation. So she was a passenger in a car and lost control and struck a tree. And she argued the defendants were negligent, driving too fast, failing to have the vehicle under control, failing to remain in a lane. And the defendants just denied liability. But for whatever reason, it was traveler's insurance, it says here. For whatever reason, it only got a settlement of $25,000. She was a passenger. She can't be at fault. Sullivan County, that's upstate New York. Here is a case in the Bronx. And what happened here was a young woman claimed a trimalleolar fracture to her right ankle with open reduction internal fixation. And she was exiting a bus and she fell because the bus didn't stop in the right place. The bus stopped near a hole. So as she was exiting, she stepped into the hole in the roadway. And so the case settled. Was it a settlement or a verdict? Actually, let me check here. It was it was a jury verdict in the Bronx, and it was $2,207,000. So a pretty good verdict for that. It was $1.8 million for compensatory pain and suffering, $300,000 for future medical expenses, and $107,000 for past wages. The total was $2.2 million. Here's one in Queens for $180,000 settlement. And what happened here was somebody suffered a supracondylar and distal humerus fracture necessitating open reduction internal fixation of the left elbow. She tripped and fell over an allegedly broken and defective driveway sidewalk apron in front of and adjacent to properties owned by the defendant. The plaintiff claimed the fall and injuries were the result of the defendant's negligence in owning, supervising, controlling, operating, managing, maintaining, repairing, repaving the sidewalk and driveway. So yeah, that was $180,000. Okay. I guess that gives you a little bit of a taste. I mean, they run the gamut. It really depends on those issues of liability, depends on damages, but ultimately it also depends on, whether the jury likes the person, whether the person feels confident enough to go to a jury and try to get a big amount. Sometimes people settle because they don't want to risk it. So when you settle, you get something, but perhaps you also lose in that, you don't get what you would have gotten had you not settled. Here's one case in Richmond, which is Staten Island. And this case involves a construction. It was a 60-year-old male construction worker. He suffered left and right comminuted calcaneus fractures. Now, comminuted means that it's broken into pieces. So that's pretty serious. Subtalar involvement with the fractures requiring open reduction internal fixation surgery, post-traumatic arthritis, radiculopathy of the neck and back, internal derangement of the right shoulder. He was carrying a wooden scaffold platform and allegedly tripped over a roundabout, I think it says, or a roustabout, and fell over 20 feet through an unprotected opening in the floor while working for the defendant construction company, who was hired as the general contractor to perform construction at a premises owned by the defendant, New York City. So you could sue New York City and there's an unlimited budget. So that's a good case. And he argued that the defendants were negligent for violating that labor law, 200, 240, 241-6. The plaintiff further argued that the defendants were negligent in failing to provide safety nets, catch-alls, lifelines, other safety devices, failing to prevent a fall from an elevated work site, failing to protect dangerous openings, failing to properly plank and cover up dangerous openings, failing to install proper plywood, failing to provide safety netting, and failing to have warning signs. The defendants denied liability, contending they did not create or know of the condition that caused plaintiff's fall, and the manner in which the plaintiff fell was inconsistent with his own description. The jury ultimately returned a verdict for the plaintiff, and they gave him $64,699 for past medical expenses, $500,000 for past pain and suffering, $195,750 for past earnings, loss of earnings, $1,412,071 for future medical expenses, $3 million for future pain and suffering, and $416,895 for future lost wages or lost salary. So the total verdict was $5,589,415. That's a pretty good verdict for, that particular venue, because that is a conservative venue out in Richmond County. But it sounds like a good case, because once you have that, the elevation related, you get liability on summary judgment, then the only question becomes your damages. And if you have the damages like the lost wages, those are actual economic damages. You can't not get them because you're entitled to them. That's what you were earning. So that becomes a really strong case. Okay, let's see what else we have here. Let's do this one. This will be the last one. This is a Suffolk County case, also out in Long Island. This one involved a 66-year-old woman. She suffered a left hip comminuted femoral neck fracture with fracture of the greater trochanter and an L1 lumbar vertebral body compression fracture, and she underwent a left total hip replacement with open reduction internal fixation of the greater trochanter. When she was walking her dog at 6 a.m., she was struck by the defendant who was backing out of a driveway, and she fell, and the defendant's rear tire then drove over her left leg. The plaintiff argued the defendant was negligent in failing to keep his vehicle under control, driving too fast, failing to keep a proper lookout. The defendant denied liability, argued that he drove into the driveway in an attempt to turn around and enter another road, did not see anyone walking a dog, and after he put his vehicle in reverse, he looked in his rearview mirror and saw nothing in the street. A jury determined the plaintiff was 35% at fault, and the defendant was 65% at fault. Months later, there was a separate trial for damages, and the jury allowed for $500,000 for past pain and suffering, $750,000 for future pain and suffering, $400,000 for future medical expenses, and $800,000 for home health care and assisted living expenses. So the total verdict was $2,450,000. That's a pretty good verdict for Suffolk County. And I see the lawyer. Oh yeah, I know the lawyer that represented the plaintiff here too. He's a good lawyer. I've watched him do some CLEs, continuing legal education. That's a pretty good result out there. And I recognize some of the defense firms as well. And yeah, so that's a good one to end with, I think. And yeah, so this is just open reduction internal fixation. And then we'll do some other videos on other topics, other injuries, as well as other incidents. Let us know what types of injuries and what types of incidents you'd like to see. Okay, everyone, have a great day. Thank you. Please like and subscribe to our channel. Ask us your questions. We're also doing the Last Week Tonight segment where we answer your questions and talk about the things that you want to know. Okay, happy holidays. Talk to you very soon. Bye-bye.